Okay, you're now live on YouTube. This together. Got one more trying to come in. All right, I think we're good to go now. Good afternoon, everyone, and thank you all for joining us for today's month of service presentation of Legal Advanced Planning and Why You Need It. My name is Nia Murray. I am the Programs Coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Cecile Carlson. In addition to that, our presenting partner on behalf of Lone Star Legal Aid, we have Ms. Jessie Campbell, who will be providing you her expertise on legal advanced planning and why you need it this afternoon. Also included in the partnership, we have the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, Houston Bar Association, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up a month of service. And for those that are not aware, a month of service is the collaboration of all of our organizations coming together on a monthly basis, offering a variety of different workshops, resources, and information to a lot of underserved communities that do not have access to a lot of information, don't know where to go for particular assistance or when they are in need, especially those related to civil legal matters. So we decided to collaborate several years ago and come together and combine all of our resources and programming and try to create a larger impact and get as much information out to the community as we possibly can. So we came up with a month of service. And basically, what we used to do was to go out in particular in different neighborhoods around the city of Houston, have a series of different workshops, and then go to another neighborhood, and then kind of making our way around the entire city. But due to the fact that we are now on a virtual platform, this has enabled us to be able to actually get more information out to surrounding counties throughout the entire state of Texas and even across the country in instances. Just know that the information that we do provide during all of our legal presentations is relative to the entire state of Texas. It is not just specific to the city of Houston or to Harris County or anything like that. So also note that the information that does get presented here today is for educational purposes only. It is not to be considered legal advice. However, we do encourage you to reach out to our legal service partners should you find yourself in need of any civil legal assistance. So again, this is your opportunity to rely on the experts to provide you all with the most up-to-date and the most accurate information. We know that a lot of folks are out there, they call themselves being knowledgeable about knowing a little bit about everything by, watching TikTok and other social media platforms and, hearing what somebody else has heard, what we call the street committee, listening to the street committee. They learn everything and they know everything. So, but we want you guys to the accurate information as it relates to the state of Texas and Texas laws regarding advanced legal planning. We know that a lot of you guys have seen, different posts and things out there telling you what to do and how to do it. And some of that stuff has absolutely nothing to do with the state of Texas. Just do keep that in mind when you're watching those different posts and videos and things like that that people are just kind of putting out there. So there's a lot of misinformation out there. You will have the opportunity to ask questions, so please feel free if you're joining us on Zoom to put your question into the chat. And Ms. Jessie's really good kind of about going through those questions as she goes along. But also note that we are broadcasting live on our social media platform on YouTube and reposting on Facebook. So we ask that you try to keep your questions to be general in nature, so that way your personal detail information is not getting out there for everybody to have access to. So do keep that in mind when you're asking the questions. However, we still do encourage you to ask if there is something that that you have. But if it's something really specific, then we encourage you to reach out to the presenter and our other legal service partners for your one-on-one issue that you're having. Um, please feel free to type your question into the comment section. And again, we'll make sure that it is read aloud. There were a couple of emails that were sent to me in advance when you folks registered to join the presentation today, and I'll make sure that those questions get addressed aloud as well. You do have the opportunity, if you're joining us on Zoom, if you don't want to type your question into the chat, wait until the end and raise your hand and unmute yourself, and you can ask the questions directly aloud if you'd like. So with that being said, there's a lot of information that you guys are going to get covered here today. By the time we get done with this, we do not expect you to be the experts, but at least you become a little bit more knowledgeable about the process, what the plans are, what makes up an estate plan, and kind of how to get some of those documents executed that you may need, that you may not have heard of. And also to dispel a lot of the myths related to asset building or our asset protection and creating an estate plan. So with that being said, feel free to come back and join us another time, or we'll send out the link of this recording so that you can go back and the presentation along with the documents that Jesse will go over today that make up an estate plan. We'll be sending out copies or templates, the forms that make up the estate plans for you all to be able to do it yourselves if you're comfortable with that. So, but she's going to get into a lot more detail about that bit. So, without further ado, we're going to go ahead and get started with our introduction. I'd like to introduce yourself, and then Jesse will have you go. Is it not working?
Hello, can you guys hear me?
Yep, gotcha.
Okay, sorry, I've been having some tech issues today. Good afternoon, everybody. My name is Cecile Carlson. I am the outreach coordinator here with the Office of Neighborhood Engagement with the Department of Neighborhoods. Nia, thank you so much for that introduction. I am very excited for today's workshop. As always, and as Nia was saying, we have information that has been fact-checked. There's a lot of information out there, but there's also a lot of disinformation or misinformation. And so what a great opportunity for us to be able to hear it straight from the experts. So Ms. Jessie, I'm really excited for your presentation, and thank you so much for being here. Thank you as well for everybody logging in. For those of you that are returning viewers, welcome back. If this is your first time, welcome as well. And on behalf of the City of Houston, on behalf of Mayor Whitmire and Director of the Department of Neighborhoods, Director Sims, we just want to welcome you guys to another session, another workshop with, like Nia said, with truthful information. And I'm looking forward to the presentation. Thank you so much.
All right, Jesse, go right ahead and get started.
All right. Well, thank you everyone for that lovely introduction, and thank you for everyone who is spending time with me live right now or watching me at a later time. We appreciate you taking time to learn about this really important topic today. And so my name is Jessie Campbell. I am a supervising attorney with Lone Star Legal Aid. Today's presentation is going to be on legal advance planning, what it is, and why do you need it. And so just a little bit more about who we are at Lone Star Legal Aid. We are a civil legal aid service provider. That means that we provide free legal services to eligible clients. That eligibility is based on income and assets. And depending on the size of your family, it's a pretty mathematical calculation. On civil legal topics, which include consumer, employment, family, healthcare, estate planning, neighborhood problems, probate. So those are just an example of the types of matters that we handle. We serve the eastern third of the state of Texas, 72 counties in total, plus 4 counties in southeast Arkansas. So in order to do that, we have 14 offices in addition to our office here in Houston, where I am. We also have 13 branch offices throughout that service area, and most of them are usually within a couple of hours of commuting difference in our service area, but it does depend. So it's just to say that while if you know anyone who may be in need of civil legal assistance and are within our service area, that we are and may be available to serve your needs. At the bottom is our website, which is lonestarlegal.org, and our universal 800 number is down at the below. Don't feel the need to write everything down right now because, again, as Ms. Nia says, you will get this information to you via email, and I'll have it again at the very end. So I will also do my disclaimer to remind everybody today that this is for educational purposes only. This is not a substitution for legal advice. And so we're going to be talking about advanced planning today at kind of a high level, like really what everybody can need to know about what it is. What I cannot do today is to provide legal advice. And what's the difference? Legal advice is about what's going on in your specific individual situation. You have a question for me of like, I have a house and a car and I am married, but I have children from a previous relationship. What type of documents do I need in effect? I can't answer those questions today because one, I have to usually ask a lot more follow-up questions in order to accurately advise you on what the next steps would be. And also you have to actually be a client of mine in order for me to be able to do that. So just keep that in mind as you start thinking about the types of questions that you are going to have. I cannot provide advice. I cannot answer specific individual situation questions. So try to focus your questions on a general, like, hey, I really didn't understand what you meant by how to execute a will. Can you please repeat that? Or, it's like, oh, when you say disinterested witness, is this what you mean? That type of thing. We're going to cover all of that in a minute. So those are just examples, but just be aware of that. And also, if you are going, please don't put any personal information anywhere in the chats or in the online, in the comments. This is a living online space that's public. Anybody can see it. And I wish I can tell you that there are wonderful people out there who are never going to do anything bad. But we know there are bad actors out there who can take information and use it against people, including identity theft. And so we want to be sure that you're not putting out any of that kind of private information that puts you and your family at risk against bad acts. All right. So with that, let's get going. Today's agenda is going to be pretty straightforward. We're going to talk about general principles of estate planning, things that apply to all the documents, everything you kind of need to know about what it is and why we do it, the difference between estate planning and probate, that type of thing. So we're going to cover that. Then we're going to go into the estate planning documents. Today, I'm not going to be focusing on how to draft these documents. Today's goal is to just explain the documents to you today, what they are, what their purpose is, and why you may or may not need them. You're going to find out that I'm going to tell you, you need all of them. But that's going to be the goal of today, is to kind of give you that introduction, understanding as to what is actually estate planning or advanced planning and the types of documents that it includes. Then we're going to talk about available resources. Within that estate planning documents, I'm going to say that my focus is going to be on preparing for death and preparing for incapacity. We will talk a little bit briefly about long-term care planning, but that in itself is a pretty big topic and really outside the scope of today's presentation. But long-term care planning is considered part of advanced planning as well. And so I wanted to give you at least some insight into what that is, so that way you can start thinking about that for your own planning purposes. Now, you will also notice that I talked about things that I'm not going to talk. I didn't say anything that I'm not going to talk about. We are not going to be talking about probate. I'm going to explain the difference between estate planning and probate in the next slide, but we won't be talking about probate today. And we're not going to be talking about how to create documents today. So we do have some upcoming programs to keep in mind that kind of fill in those gaps. First up is the next Thursday, in 1 week from today, we have how to handle inherited property. including clearing title and probate concerns. That is online, the same way you registered and was able to watch this video. And this presentation is the exact same way that you can sign up and watch that video when it airs next week. So that would be the second, that's the other side of the coin. I'm doing one side of the coin, estate planning. The other side is the how to handle inherited property on the other. So if you are here today because you have questions about someone who has passed away and you're wondering what to do next, that is going to be the appropriate session to attend. Then in a couple of weeks, on Tuesday, October 22nd at A-Leaf Neighborhood Centers, we are going to be having an in-person coffee and conversation resource fair. Me and my team will be there in person to be able to accept applications for legal assistance in person if you wish to attend in that way. You can also apply in other ways, but if you want to attend in person, that's a way to do that. And if you do have specific questions that you want to have answered, that's also a way to come and meet us in person to be able to provide that advice on site. I will say that it is because I cannot provide advice until and unless you are a client of mine, you do have to complete an application for services. Highly recommended that if you are planning on coming to that resource fair, that you apply for services before you come, either online or via phone, with either Lone Star Legal Aid or one of the partners that will also be at that resource fair. And then finally, on Thursday, November 7th, I will be back to do part 2 of this presentation, which is going to be the in the weeds conversation. I'm going to go through some pro se forms. Those are forms that you complete yourself. And so if you are wanting to try to draft your own documents, I spend 2 hours talking about how to complete the Supreme Court, the Texas Supreme Court approved pro se wills form, as well as a transfer on death deed document. You'll learn more about that in a minute. And to be able to talk about how to complete those on your own. And that's going to be on November 7th. It will also be online. And we are at TBD for an in-person location. So don't hold me to that. But all of that information, you'll get the information from if you are signed up for our newsletter with NRCDC. And of course, you can go to the website for nrcdc.org to be able to get that information and follow us on all of our social medias. All right, now with that, let's get going into the topic on why you are here. So what is advanced planning and what's the difference between advanced planning and probate? I've already mentioned that a couple of times. Opposite sides of the same coin. One is before, one is after. That's effectively what it is. One is before a person passes away or death, before a person becomes incapacitated or no longer able to make decisions for themselves. And the other is after. Now, it's a little bit misleading for me to say probate is everything after, but generally, when you hear people kind of use the word generally not in its true legal definition, probate usually is talking about what happens after a person passes away. They're kind of encompassing the whole thing, although legally the definition is a little bit more specific. So advanced planning is preparing for death and incapacity and the care of minors or adults living with a disability under our care. So those who we have formal guardianships over or informal guardianships, in the event of our own death or incapacity, and we are no longer able to care for our children or the individuals under our care, as well as long-term care planning. Putting all of that decision making, what you want to happen, who do you want to be responsible for making those decisions and making the choices that you want in effect, putting all of that into a written, legally binding document. That is all estate planning is. It's preparing. It's just preparation. And it's highly recommended that everybody have preparation documents in place because one, everyone is going to pass away. It is a reality that we all have to face. And there is a possibility that you may become incapacitated, and that can create a lot of issues for family members to provide care. So we want to be sure that they are empowered if that need should arise. So then what is probate? Probate, again, is that after side. Legally, as I mentioned, that kind of specific language. Legally, probate means the court process of handling an estate after a person passes away. That's the technical definition of probate. But again, a lot of times you may hear people talk about probate, and really they're just talking about anything that happens after a person passes away. But that's not, again, 100% accurate. So when we're talking about the court process is filing an application in court with an attorney. Typically, in the majority of situations, you do have to have an attorney to represent the estate in the probate court. That and during this process of managing the estate, then we are paying off debts, conveying property ownerships, and then managing issues for children under our individuals that were under our care. What happens in that probate process, how quickly it is, how easy it is, how expensive it can be, whether or not we need to go through a formal court process, all is dependent on what type of advanced planning documents exist. Do they exist? If they don't exist, there's a completely different set of steps that needs to be taken to be able to handle the estate, versus if there is documents that exist, what do those documents say? How were they executed? And then that will determine what happens next. And so that is the reason why advanced planning is really important, because really well drafted, properly executed documents makes the probate process, the after process, significantly easier for the heirs and beneficiaries and the family members who are now having to manage the estate or affairs of the person who has passed away or who has become incapacitated. And so while I've been talking about probate as being the death process, there is a court process for incapacity, which is guardianship, is setting up a guardianship, and there's a court process associated with that. And it's the same thing, what documents are in place, and that can help move that process forward a little bit more easily for the individuals who need to put that into place. We are not going to be covering the probate process today. As I said, there's another session in a week that will cover that, and you will see why. It's just too much information for us to cover in one session. And so please, if you're asking questions about that, I am going to defer you to please come back next week. All right, so I'm going to highlight some key takeaways that I hope that you keep in mind. There's a lot of information that's going to be said to you today, and I really want you to walk away with 4 key takeaways. So the first key takeaway is that someone must do something when a person passes away. Drafting the documents is not enough. They have to know that they need to do something. So I usually put this at the front end of it because, one, I think it helps solidify what I would say, which is everyone needs planning documents in place because of that need to ease the probate process if one is needed. And then to kind of put it into your minds that it does need to be done. And that thing is to take whatever documents have been drafted and to go to an attorney. That really is the thing that needs to be done. When we're talking about what happens after a person passes away and what is the next steps that we need to do, we are really truly talking about a hypothetical situation. We are anticipating right now what will be the situation when we pass. So that's why we're writing our documents in such a way to anticipate what the living situation is going to be as it relates to our property and our finances, etc. But we won't really know until that happens in that moment in time. That's when we're going to want to take a look at, what do the documents say? Are they valid? And are they doing what we needed to do for the situation? Who are the heirs at this point? How old are they? Are they living with disabilities? Is there debt that we need to worry about? What type of debt? What type of assets we're going to be having that currently exists in the estate at the time of the passing? All of those are, I don't know, answers, right? Like, I can't tell you what's going to happen right now because it doesn't exist yet. It's a future event that we don't know what's going to be. So it really is a situation where we need to kind of look at that you reach out to an attorney to be able to know how to handle that. All right. The next thing is that estate planning is an individual plan. It's really important to realize this, that we're all not the same. We don't look the same. We don't have the same situations. All families are different. And you're going to be taking a look at your own situation when you're drafting your documents. So it's going to be based on your family members and those dynamics. I wish I can say everyone has really happy family dynamics, but that's not always the case. People do become estranged when they're no longer in contact with family members. There's disownments. There's also other aspects of it, which is who are the better people, quote, air quotes, right, to handle things. There's someone with a particular need that needs to be addressed that may not be the case in another families. We look at the type of property that is owned. Who is inheriting? Do they have any special needs to take into consideration? We don't go into too much detail on this today, but things that you do need to take into account is your heir, the beneficiary of your will, a person living with a disability? If they're living with a disability, we may need to do something known as a special needs trust if they are receiving government benefits based on that disability, based on income. And inheritances can disqualify that individual from receiving their government benefits. And so we would want to take a look to be sure that we are putting the property in such a way that doesn't harm the beneficiary from those much needed benefits. So that's an example. So that's not the only example of why we need to see who's inheriting the property to be able to know what the next steps are, properly preparing for that. We're going to want to take a look at your current health situation, especially as it relates to incapacity documents, but across the board. Current health situation does impact aspects of all three, planning for death, as incapacity, as well as long-term care. So we would take a look at that, as well as any long-term health condition or family history. Sometimes we know that we have a strong family history of incapacity, and we're anticipating that for ourselves. There's always advancements in medical science, and so that doesn't mean it's guaranteed that it will happen, but because it's like, well, grandpa had it and uncle had it, so far dad's fine, but that's two generations, and that we know for a fact had it, so I'm going to prepare for it. I'm going to anticipate the possibility for it, even though I'm hoping it doesn't happen, right? So we also want to take a look at those types of things in your individual situation. The reason why it's important that I bring that up and for you to understand that is because not all documents apply to everyone. So even though I'm going to have a session in a month talking about how to use template forms, you don't necessarily want to take a form and just follow it. You want to be sure that when you look at a form or a template, that you are being critical, that you are looking at it to be sure that that form or that template, if you're drafting them for yourself, really truly is going to accomplish what you want to accomplish. And on a lot of these templates and forms are basic. Do they apply for a lot of people? Yeah, they really do. But for a lot of people, it doesn't, right? Like, as I mentioned, these special situations, they may not apply in those cases. And then in which case you may want to need to seek out legal counsel to help draft your documents to get what you want to happen in the event of your death or incapacity. So when you want to update your documents or draft them. And so the thing is that, like, it's my personal opinion as a lawyer, that as soon as you are aware that you need advanced planning documents, that's the time to draft them, right? So you are here today, you are watching this presentation today. Now is the time to do it. I have a joke, and it's really not a joke. I'm of an age where I have a lot of friends who are attorneys whose children are becoming young adults, and I have a handful that made jokes that one of their gifts to their children when they turned 18 was estate planning documents that they hired an attorney on their behalf to help draft them. And they're just like, wow, that's grim, 18 years old, you're not thinking about that kind of thing. But that's how lawyers think, right? We're like, well, everyone needs it. Accidents happen at any time. I mean, that's the reality. Accidents can happen, illnesses can happen at any time. And so you want to be sure that you're prepared for it at any time. Now, once you have your documents drafted for wherever you are in your current state of life, you're going to want to take a look at them through afterwards. Like, just because you've done it doesn't mean that they're set it and forget it. You want to be sure that they reflect any changes in your current situation. So you're going to want to update it when there's a major life event, such as a change in marital status. That would be marriage, divorce, and widowhood. children, that includes the birth of a child. Hopefully no one experiences the death of a child, but this also includes when a child ages up, when they turn into adults, and as they turn 18 years old, and at that point in time, also a reflection of whether or not that child is living with a disability. We would want to be taking a look at that time frame. So we would want to be looking at that. You want to take a look at them when you have health changes, particularly as it relates to your medical documents that you would be preparing. And then, of course, major property changes, the purchases of a property, to some degree, the sale of a property, depending on how your documents were originally drafted. But you're still going to want to take a look at all of that. Major property changes doesn't mean just big purchases, right? It also can include inheritances. Did you inherit a family heirloom? Is there a piece of jewelry or antique that is really important in your family that has tradition around inheritances? You would want to be sure that that's reflected in documents. So again, individual plan, but that's where you're going to want to look. It doesn't mean you have to change your documents. It just means you want to be sure you look out and be sure it's still accurate and reflective of what you want to accomplish. Without any major life changes, I do recommend you still review them on a pretty regular basis. Some people do it once a year. I don't know if that's necessary if you're not having any major life changes. But at least every few years, maybe every 5 years, if you're not looking at it on a regular basis, to be sure that it's still doing what you want to do. And if it is, no need to change it. The laws will be still in effect. But that would be the recommendation. In all of these documents, you are going to have to choose a representative. And so when you're thinking about who to choose, you're thinking about who's going to be acting on your behalf when you're not able to do so. That's really what it is. It's putting somebody into your shoes to make those decisions because you're not able to do so yourself. And so when you're picking somebody, it should be somebody you know and trust who will do as you would do. Right? Like, because that's what they're doing. They are a substitute you for all intents and purposes, right? And so you want to pick somebody that you can trust to be able to do that. And also, if there isn't specific instructions and directions, then you would want them to do what's in your best interest and as you would do for yourself as well. And so that's the type of person that you're going to want to pick. So what does this mean in the counseling side of things? This person may not be the obvious natural choice. I have a lot of people that this is a very emotional decision. And it's not uncommon to have a client who is unable to move forward with finalizing their documents because they cannot choose a representative because of fear of hurting someone's feelings and making people think that they don't trust them or things along that lines. Choosing the best person may not be your spouse. It may not be your oldest child. Some examples for that. I have couples who come in who have been married for 50 years and, they're already planning for the future, right? And they're not picking their spouses, not because they don't trust their spouse, or that but they're thinking, we've been married for 50 years. I don't want my spouse to have to be worrying about handling estate work and making decisions. I want them to have to be able to focus on their own recovery and their grieving. And, because I'm going to be gone. This person who's been part of their support for 50 years is now gone. And I don't want them to have to worry about this. I'm not picking my spouse to serve in that role. I'm going to pick somebody else. Other types of examples will be, I may not pick my oldest child because they're my best friend. Like they're, I know that they're going to be hurting, and they're not going to want to be dealing with that. I don't want them to have to be dealing with that because they're going to be grieving. It's not difficult, but it is work. Like there's stuff that has to be done, right? And so it's like, so you may not, and they're like, so I'm going to go ahead and pick my brother, the accountant, to serve in the role as the executor because there's a lot of paperwork. There's a lot of finding documents, sending letters, things like that have to be done depending on what's in your estate and how the estate's going to look. And it's like, let him do it. And yes, while he will also be grieving and while he will also be sad that he has lost a sibling, at least brother is going to have the mental capacity and more the emotional capacity to be able to handle the work, allowing my oldest child to grieve. And so it's like, so think about it that way. Now, it could be your spouse, it could be your oldest child, it could be whatever, right? Like, I'm not saying that you can't pick the obvious choice, but it doesn't mean that it necessarily has to be. And you shouldn't feel obligated to pick somebody because they think they're the person who should be in that role. Remember, individual plan, what's right for you, what's right for your family, what are you trying to accomplish? And that is what you should be thinking about doing. So it's really important, though, that once you have made that decision and you have picked, regardless of who you pick, whether it's a natural choice or not the natural choice, have conversations with everybody about this decision. Talk to the person that you have picked to tell them, to empower them, to actually tell them, like, hey, I've selected you to serve in this role, just to give, let's have a conversation about how I would do things, what I mean by what I've written here. These are the types of decision making that I would make in some fact patterns, so that way they have the knowledge to empower them to be able to do what they need to do if and when that situation arises. You're also going to want to have a similar conversation with the people that you don't pick. You're going to want to explain that you're no longer here to be able to tell them why they were not the ones picked. And whether we like it or not, people create stories in their heads about what's going on. And I just had that happen to me pretty recently, where I saw something and I just created this whole scenario in my head. And I'm like, what am I doing? I don't know if that's really what happened, and it just took a phone call to clarify exactly what happened, right? You just, so like, that people will do that, not to make light of it, but people will do that, and they're going to be hurt, and they're going to feel like, why wasn't I trusted? Did they not love me? Did they not believe that I could do what they needed me to do? So you're going to want to explain that and say, look, this is a loving decision. It's not that I don't trust you. You're my number one person. I love you more than, anything. But I also know that I'm your number one person, and this is going to be hard for you. And I don't want this to be hard for you. That's why Uncle Bob's going to take care of it. Uncle Bob's not going to do anything without your support and understanding, and not going to do anything to hurt you. That's how much I trust Uncle Bob to do it. I'm doing this as a gift to you because I love you, right? So you want to have those conversations so that way people understand when you're not there to explain it to them, the whys. The other thing to consider when you're choosing a representative is that it is highly recommended that you do not select more than one person to have shared role. Be sure you're picking one person. A lot of people want to have shared roles because they have more than one child, and they want both children to not feel like there's a favorite, even though there is one. No, I'm just kidding. We know, there isn't, right? We love our children equally, and so there is, but it's like you do want to still select a person because it can become extremely complicated. One of the reasons why we try to have advanced planning documents in place is to avoid conflict, confusion on what the plan is, what's going to happen. Shared authority can create a lot of conflict and problems, and then this whole goal to try to avoid having to go to the court and having the court make decisions for us on our behalf, causing expenses involving attorneys and things like that. Can be solved by just not having dual authority, by having only one person in place. Think of it this way, in the way that I was in my own conference where someone was talking about this. Do you want two people driving a car? Who do you want to be driving the car and making those decisions? And then maybe, talk to other people about who should be the map holder, if there needs to be a map holder. And in all of this, be sure you have an alternate and have similar conversations with the alternates. All right, so now let's start talking about the documents in themselves. The majority of this presentation is going to be on death, explaining the will. So just be prepared for that. But so don't get nervous when we're like all of a sudden it's a long time in and we haven't gotten to anything else. So the second key takeaway for everyone to be aware of is everyone needs a will. To me, it actually doesn't matter. I get so many questions afterwards where people will say, well, what about this situation? Do I need a will? What about that situation? Do I need a will? Yes. I don't even know the situation. I really don't. The answer is yes. It's like, because it is better to have a will and not need it than to need a will and not have it. It is not having a will in the probate process can be very, very difficult and very expensive and time consuming, and can take years to solve the problem at hand. And so if you just had a will, it will solve it. I'm going to talk about this a little bit more as I go through this presentation on the will topic. But that's the second key takeaway. Everyone needs a will. So first you need to understand what happens at property in the transfer of ownership after a death. There's a lot of misconceptions about what happens to property when a person passes away. And that is usually the reason why I get the, oh, I don't need. When in reality, we do need to do some planning around it. So the first kind of misconception I get is, I don't own anything. There's, what I usually hear when people are telling me that is that they believe they don't own anything of value, of high property value. That would be a house or a car, or, you know, stocks or something like that, right? Like, so that's usually what I hear when people are saying, I don't own anything, which is untrue. Everybody owns personal property. So you have your clothing, your jewelry, that you have, your furniture in your place of your home, right? And so we all own something. And by the way, your bank account. Right? Your bank account is personal property, and you own that. And a lot of people, not everyone has a bank account, but everyone, most people do. Most people have a bank account. And so all of that is personal property. And that is subject to the probate process. And so, and now whether or not you need to go through the full court process, again, depends on that. When I talk about the beginning, do you have a well-drafted will? Do you have a what the situation is and things like that. It's kind of hypothetical, but someone has to have access and be allowed to come into the home and take the property and do something with it. Sell it. Are we selling it? Are we just anticipating the family is going to just take everything? If we are selling it, who's getting the money? How's that money being distributed? Is someone being expected to be reimbursed for something and then the rest is split among people? Maybe it's a charity. What about family heirlooms? Are there family heirlooms? And by the way, heirlooms don't necessarily have to be like things that have passed down for 8 generations. You'd be surprised what things become emotionally have items that become emotionally attached, right? That, oh, I really, really wanted dad's coffee mug. Like we spent every Sunday morning on the porch, drinking coffee, talking about our week, before we head to church. And I would love to be able to take his mug and do that with my child in the future. Right? That's a highly emotional, sentimental value thing. Not sure you need to put that into a will, but maybe you do. Maybe there's 3 kids who sit on the porch with dad having coffee before church, having conversations, and all 3 want the mug, right? So family heirlooms and things like that can actually attach pretty quickly. So you're going to want to take a look at that kind of stuff when you're looking at your personal property and whether or not you need to put that instructions into a will. Someone must have the authority to distribute that property, right? I've already mentioned like who can go into the house, who can grab the things and do what they need to do, and the instructions on what's going to happen as a result of the proceeds. Beyond that. Now we're talking, and then now we have some misconceptions as it relates to title property. So those are going to be cars and houses. Um, there, there is by operation of law. So this is true. By operation of law, the property automatically passes to whoever the heirs is upon a person passing away. So there is kind of like this ether thing, right? In the space of knowledge, in our collective legal knowledge, that when a person passes away, their property is owned by somebody else. That's really kind of that is a real thing. But that's a misconception of what really is happening. Title property still has to go through some type of legal process to clearly say who now owns it. Otherwise, when I talk about it being in the ether, what we're talking about is a cloudy title. We don't actually know who owns the property. It's unclear. We know something happened because by operation of law, the property belongs to somebody, right? It should belong to somebody. And so it's like, but we don't know who. That ether thing, that cloudiness. So it creates a cloudy title. That can have a big impact on the property value, the ability to sell the property down the line. Just straight up ability to sell the property. Sometimes you can't because you don't know who owns the property. Other things is even if you're not planning on selling the property, not having clear title to a property can impact ability to get insurance on the property, get property tax exemptions, qualify for assistance in the event of a disaster, who to get disaster assistance. So all of that can impact the ability that the cloudy title can impact all of that thing. So what you need to be aware of is that we have to go through a process. We have to go through either a probate process or an alternate process, which I'm going to talk about in a minute as I talk about the documents. So so we all have to kind of be aware of that we still have to do something in order to transfer the title to somebody so that the law and the public in general knows who owns it. Verbal agreements are not enforceable in the state of Texas as it relates to property. So these understandings that I get, people will be like, oh, we have an understanding that the property is going to go to Big Sis because Big Sis is living in the property and everyone knows that's what mom wants. And so that's what's going to happen. Guess what's not enforceable in the state of Texas? Any of that agreement. So if you actually want it to be in effect and you really want Big Sis to be able to stay in that house for as long as she wants and as she needs, then that needs to go into a will. So that way it can be enforced by a court, because otherwise that property, there's 3 kids, all 3 kids own that property, and assuming that they go through the clearing of the title, and once they clear the title, all 3 of them, in theory, one of them can force the eviction of Big Sis, right? So just know that that's not a true statement. That just because you have an agreement doesn't mean it's enforceable. It definitely isn't enforceable. And so put it in writing. Just make sure it's just in writing. Co-owners of property do not automatically get the property when the other co-owner passes away. That's also a misconception. It is, in some situations, the answer is yes. So if you are married and your spouses and your children or all of your spouse's children, by law, if without a will, the person who would inherit the property is the spouse. Now, remember what I said, everyone still needs a will. But because the reason why you would need a will in that situation is to avoid the very expensive, costly probate process that would happen without a will. But in another situation is that you're married, but your children are from a previous relationship. Your property doesn't pass to your spouse. Your property passes to your children from your previous relationship. Now, that may be what you want. And then you would just want to have the will in place to avoid the expensive probate process. But it may not be what you want, right? Maybe what you want is your spouse to actually inherit the property and not the children. And, or you have some other situations and conditions that you want to put into place. So co-ownership does not guarantee that the other person now owns it. And that is a very common misconception because of the nature of community property in the state of Texas. Oops. Okay. All right. Sorry, I think I saw a question. All right, I see some questions. I'm going to get to everything in a little bit. I know I've been bringing up terms, so I'm going to get there. So bear with me. All right. So first up, let's talk about the last will and testament. So what is a last will and testament? A will is a legal document in which a person called the testator writes down what they want to happen to their property and debt, called the estate collectively, after their death, and who they want to manage that estate. That person is known as the executor. That's all a will is. It's really just it really is in effect a simple document that, but that's really the ultimate goal of it. Now, it only covers probate assets. So let's talk about what that means. Well, I already discussed that a probate is the court process, right? So a non-probate asset is a property that's owned in a way that ownership transfers to a specific person without going through the probate process. This is different from when I talked about co-owners. We're not talking about that situation now. We're talking about specific property, the way it's owned in Texas. You're going to be able to pass it without going through the probate process. So the big one for a lot of people is retirement accounts, IRAs and 401ks, etc. Those, you're going to name a beneficiary with your financial institution that holds those accounts. Life insurance proceeds, you're going to designate a beneficiary for your life insurance proceeds. And then there is a payable on death account. That's going to be for your bank accounts, your savings account, your checking accounts, and things like that, that you're going to have has a beneficiary. You're going to name that as a beneficiary. So what happens when you have these designated beneficiary documents? We're we're going to deal with those three first. So retirement accounts, life insurance, proceeds payable on death. When the person passes away, you're going to contact that financial institution and you're going to say, hey, the person has passed away. They're going to say wonderful or not wonderful. They're going to say, so sorry for your loss. There's a beneficiary on the account. We need a copy of the death certificate, and here's the forms that you need to complete for us. And then then they're going to either transfer it, or in life insurance, they're going to write a check. That's it. That's the process of designating a beneficiary. No need to go through the probate court because you've already said what you want to happen to the property. When you don't have a beneficiary designated in any of these properties, they will become part of the estate. That's what's actually going to happen to it. They don't go, so they're going to become part of the estate that will be handled through the probate process. So it does become a probate asset if there's no beneficiary listed. Now let's talk about, we're going to go through some scenarios here to kind of solidify the point of why you need a will, okay? But to kind of explain the process of what happens when things are not in place. So again, let's use life insurance policy for $5,000. You have named a beneficiary to Bob. Bob's going to get the $5,000 after completing the thing. Full $5,000. Check for $5,000. That's the policy. Now, there's no beneficiary listed. Silent to the beneficiary listed. Now the life insurance company is going to pay that to the estate. Now it has to go through the probate process. You have a will that is drafted that says that the entirety of the estate is going to go to Bob. So that $5,000 is supposed to go to Bob. However, we have now had to hire an attorney to go to probate court with the will. And so now that, let's find a really great inexpensive attorney, and then they're going to charge you $500 to do that. And so now instead of getting the full $5,000, Bob's going to get $4,500. Not a big deal. Probate is actually not a big problem in the state of Texas when it's well drafted and you have it, right? It's just you're hiring an attorney and they have to do the work, and it's going to be $500. And so now Bob gets $4,500 instead of $5,000. Now, what happens if there isn't a will? Now we're going to go through a probate process that requires a determination of an heirship. Depending on how complicated the family dynamics may be, say that it is, there is no will, but Bob is one of three siblings, right? And we don't know if there's a fourth sibling someplace else. So the court may order. So now you have $500 for your attorney that you have hired to be able to go to court. Now the court says, hey, we need an attorney to represent the unknown heirs, and they're going to be able to have to go look for that. That attorney, by the way, has to be paid by the estate as well. That attorney is going to cost $500. Right. And so now we're down to $4,000 is remaining in there. And Bob, who you had wanted to get the entirety of the proceeds, is one of three children. And so now that remaining $4,000 is divided equally among the three children. Instead of Bob getting the full $4,000, they're each going to get $1,200 and $500, something like that. Right. And so it doesn't get what you wanted to have an effect. And even though you may have verbally said somewhere, by the way, Bob is the one who needs the money. I want Bob to get all the money. Not enforceable in court. Right. So that's kind of a very quick scenario explanation on like why it's important, one, to designate your beneficiary because it saves a lot of money and get your heirs the full benefit of the account. Two, it demonstrates why it's important to have a will because it reduces the costs for the probate process, and it guarantees that the person you would want to get the property gets the property. And so that's kind of the illustration of that thought process. All right, so now let's talk about joint tenancy with a right of survivorship. A joint tenancy with a right of survivorship is an agreement with two people that upon the death of one, the property goes to the survivor. So remember what I said, co-owners does not guarantee that the property passes to the other co-owner. That is the standard law in the state of Texas. Generally, you can only pass the interest that you own, your 50%, assuming you're co-owning two owners on the property, your 50% is going to pass according to your will, according to your heirs, etc., right? So it's a completely different entity. It's separate from the 50% owned by the other person. A joint tenancy with a right of survivorship is saying, hey, no, I definitely want the money to go to my co-owner. That's not the default. You have to create the property in that way. You have to make it into a joint tenancy with a right of survivorship. The default in the state of Texas is the first one. It's that you own your portion of the property and it passes according to the way you want it to pass, right? Like, and that is, whereas this is turning what is typically a probate asset potentially into this automatic transfer of ownership to another person. So I always recommend extreme caution before you do this, because it typically can't be undone. It's very hard to undo. Everyone needs to agree to undo it. And if there's a possibility of you changing your mind that this is what you want to happen, you may not be able to change your mind. And so there are alternatives. I'm going to talk about that in a second. Again, that elusive transfer on death deed I keep mentioning. I'm going to talk about that in a second. But there's other ways to kind of create the same effect. But that is a possibility to have this joint tenancy with a right of survivorship. You can also do that with bank accounts as well, by the way. You can create joint tenancies with bank accounts. Everything else is a probate asset. Anything I haven't mentioned is going to pass according to the will. Again, we're going to talk about other things, but otherwise everything in theory is subject to the will and will pass according to the will. Okay. So what is another key takeaway here? Access to the bank account. So I mentioned the non-probate assets of payable on death accounts and joint tenancy with a right of survivorship. I mentioned bank accounts in those two situations. You're going to want to be sure that they have access to the bank accounts because there's usually, for a lot of people, three major pieces of property that they worry about upon their passing. The first one is going to be their house. Second one's going to be their car. The third thing is going to be their bank accounts. The bank accounts can be handled through these non-probate options. So you can make your bank account into a payable on death account. That's probably the easiest one to do. You go to your financial institution, you say, hey, I want my checking account to be a payable on death account. You're going to name your beneficiary, and then that's going to be able to take care of that. And then they will supply a death certificate, complete the paperwork, and then they'll get access to the accounts. So there's that, right? Now, the other option is that you can create co-owners in the account. You can do that joint tenancy with a right of survivorship, or you can just do a co-owner where it's not that joint tenancy. They're just co-owners. They own their portion of the property in there. And then they have access to the account after a person passes away because they are an owner. But because they are an owner, which means even before a person passes away, they have access to it. They can go in, they can write a check, they can withdraw the money, and etc. Right? There's no right or wrong here. It really kind of depends on your family dynamics and what you want to do. Most people do a payable on death account because that works for them, but but sometimes people automatically go ahead and put somebody on as a co-owner because that person's already helping them, right? Like elderly individuals who have older children or friends or things like that who are kind of helping pay their finances and manage their bills and things like that may already have become co-owners on the account, so that way they can do that work that they need to do to pay the bills and etc. Right? That's usually kind of what I see, but again, there's no right or wrong here. I've also seen it where someone has added a child to the bank account as a joint owner. Child has nothing to do with anything, right? They're not helping. They're not helping pay bills. They're not doing any of that, but they're on the account as part of their estate planning. So that child has access to the bank account immediately upon passing, and child is just like aware that it exists, but doesn't do anything with it. So there's kind of various options that you can look at that make sense for your family and your dynamics, but you want to be sure that you have something for your bank account. When you have something, because even if you do need to go through a probate process, there's still going to be expenses, people paying funeral expenses, ongoing payment of bills until the probate process is complete. And those people are still going to need to have access to the bank account to be able to make those expenses. Because the estate is still responsible for that until the estate's settled. But just kind of be aware that you want to take a look at your bank accounts. Okay. All right. So now let's talk about the types of wills. I'm going to kind of go through this pretty quickly because of the new the second session that I do next month on how to draft your documents. So this is just so that you are aware of what wills are and what the requirements are. We're not going to go too detailed into the specifics about what they need to say and that kind of stuff, because we're going to do all that in a month. All right. So the first type of will is a holographic will. A holographic will is 100% in the testator's own handwriting that is signed and dated. So you're going to take out a piece of paper with your pen, blue pen preferably. You're going to write out your will. I, Jesse Campbell, being of sound mind, this is my last will and testament. I named my brother Bob to serve as my executor. I leave everything to my dogs, signed and dated, period. That's a valid will in the state of Texas. Is it a good will? No, not really, but it's a valid will. Has all the components that you need in it. It says my name, it says it's a will, it says who I want to serve as my executor, and it says who I want to inherit all of my property. And then I signed and dated it. That's all that's needed for a holographic will to be valid in the state of Texas. It needs to be 100% in your own handwriting. This is not something that you can delegate to somebody. So you can't dictate your will. So it cannot be you're sitting in a bed and be like, hey, Bob, I would like you to write down in your own handwriting a will for me. That is not going to be considered valid in the state of Texas. So, so just be aware of that. It has to be 100% in your own handwriting. When admitting a will with no witnesses to court, again, you don't need witnesses. What I explained, that's it. That's all that's required for a valid will in the state of Texas. When you're admitting a holographic will to the probate court, the executor will need to bring two witnesses to testify to the testator's handwriting. So, Your Honor, here's a handwritten will by the decedent. Judge is going to be like, fantastic, I need two witnesses who can come in and testify to the handwriting, but they have to be disinterested witnesses, people who have nothing to gain from the will and they're not related by blood marriage or adoption, are not owed money, like they have nothing to gain, right? And they have to be able to know your handwriting in the normal course of everyday life. I don't know about you. I don't know very many people who are not interested in me who know my handwriting. Most of the people who know my handwriting are people who get Christmas cards from me or letters from me, and so a good chunk of them are people I'm related to. And so, so you may be able to find co-workers depending on whether or not people do a lot of handwriting with that. And those finding two witnesses for that situation can be very difficult. So be aware of that. The reason why I mentioned that on the probate side of things, because as I'm telling you about how to prepare your estate planning and you're thinking, oh, I can just write my own will, be aware that if you do that with no witnesses, that's a valid will, that's true, it can create complications in the probate process because there is no witnesses, two witnesses that are available that can testify. So that means it's optional that you can have two witnesses to the will. So you can write your will and then you have two witnesses watch you do that. And everyone's watching everyone do it. And then you sign and date it. Witnesses see you sign and date it. You're going to watch the witnesses sign and date it at the same time. And then what you have is now a witness will. And so what happens when you admit a holographic will with witnesses, the executor is going to show up in court and be like, Your Honor, here's a witness will. Now the judge is going to say, fantastic, I need one of those witnesses to come to court to testify. The witness is not coming to testify to your handwriting. The witness is coming to testify to seeing you draft and execute the will and that you were of sound mind at the time of drafting the will. So that's going to be the purposes of that. So I explain all of that so that way if you do want to go do this on your own, you understand the impact of drafting a handwritten will without witnesses and the high recommendation that if you were to do that, to have witnesses as part of that process. So the second type of will is an attested will. An attested will is 100% typed. So holographic, handwritten, 100% handwritten. Attested, typed, 100% typed. That's either a typewriter or a computer that's printed or anything like that lines. It's one or the other. 100% handwritten, 100% typed is the attested will. So again, you take out your handy dandy typewriter, clickety clack. I, Jesse Campbell, being of sound mind, write this as my will. I name my brother Bob to serve as the executor. I leave everything to my dogs. Period. Print it out. And now you are required to have two credible witnesses over the state of Texas. So the holographic will, handwritten will, no witnesses required. But for a typed will, It is required in the state of Texas to have two credible witnesses over the age of 14. You're going to find later on that every other document requires witnesses to be over the age of 18, but for a will, it is only over the age of 14. So if all you have available to you is your neighbor with mom and their 16-year-old teenage son, that's your two witnesses. They are disinterested, or and they can come over and they can witness the will. So now you have a typed will. You're going to witness it. You're going to watch each other do it. You're going to sign and date it. Witnesses are going to watch you do that. You're going to watch the witnesses sign and date it. They're going to watch each other. It's just a big old, think of that Spider-Man meme where all will just looking at each other doing signings. Like that's just what we're talking about. And so that's what's required for a type will. And so just like the holographic will, when you have witnesses, you're going to go to court. You're going to be like, Your Honor, here it is. Here's an attested will with witnesses. Your Honor says, I need one of those witnesses to come. They're going to testify to have witnessing the will being executed. So they're like, what happens, Jesse, if there's no witnesses available? That seems hard too, even though I don't have to worry about my handwriting. What happens if the witnesses are gone? People move, people also pass away, and when we can't find them? What if it was my neighbor and we weren't really good friends? They were just doing me a solid by it being, things. So what do you do? That is where what is known as a self-proving affidavit comes in. So usually I get the question at this point in time, are you required to have a notary? No, you're not required to have a notary for a will to be valid. It just has to be 100% in your own handwriting, or if it's typed, has to be witnessed by two credible witnesses over the age of 14. That's what makes a valid will in the state of Texas. But the self-proving affidavit is where the notary comes in. And so that's why when people are like, oh, no, you have to have a notary. No, you don't. You only need a notary when you're doing a self-proving affidavit. So what does a self-proving affidavit do? It is a document that is kind of given, it proves the will. It proves that the will was witnessed and properly executed is really what it does. And so yeah, you've gotten your will, you've signed and dated it, your witnesses have signed and dated it. We now have a self-proving affidavit that's attached to it that is also now signed by you, signed by your two witnesses, and now you're going to add a fourth Spider-Man into our little triangle of witnesses, and your notary is going to be watching all the signatures happen at the same time, and now they're going to notarize this self-proving affidavit. And then what happens is that when you go to court, Your Honor, here is a self-proved will. And you can do this with a holographic will, a written will, a handwritten will, plus a typed will. You can do it in both of these. Your Honor, I now have a self-proved will. Here it is. Fantastic. Let's swear in your executor. That is exactly what happens when you are able to do this with a self-proving affidavit. So how do you kind of decide what to do? All best situations are to have a self-proved will, obviously, right? It's the easiest thing. It makes the probate process less than 10 minutes. You don't even have to find anybody. The notary doesn't even have to show up, right? Like, unless it's contested and stuff like that, but that won't happen, right? So it's that's it, right? So you're going to want to try to do a self-proving will if you can. If you can't do that, it's probably recommended that you have a witness will, either typed or handwritten. You're going to want to have witnesses, and you're going to want to find two people who can come in and do a witness, and hopefully they're people that you'll be able to find later on down the line. And if you can't have a witness will, then you're going to do a handwritten will on your own, right? And then hope that you have two people who can do that. If you're going to do a handwritten will with no witnesses, you may want to create a list of people who know your handwriting that are disinterested that your executor can call to testify. That would be kind of the practical advice if you opt to go in that final route. But best one is going to be a self-proof, probably typed will that's witness, right? You're going to want to do that, and then you're going to want to do witness wills, and then you're going to do a handwritten will. Okay. There is no requirements to do anything with the will after that to make it valid. You don't have to file it with the county. You don't have to go send it anywhere. You don't have to go to the court. You just have to be sure it's in the safe place that your executor knows what to do. Can you do some of that other stuff? Yes, but you don't, filing with the county clerk. You don't file it with the court, but you can file it with the county clerk if you wish, but it's not required to do so. Okay. All right, so now that brings us to types of wills. Fill in the blanks. What about these fill in the blanks will, Jesse? I see them in Home Depot and, or online. Why can't I use those? In the state of Texas, they're not valid. Fill in the blank wills are not valid in the state of Texas. They have to be 100% in your own handwriting or 100% typed. as is what the law says. Now, you're going to say, what about those Supreme Court forms? Jesse, you mentioned that a little bit earlier. The Texas Supreme Court has approved some pro se forms that are for people to be able to draft their own documents. They are fill in the blank forms when you look at them, right? Because they're a template. They're going to have little sections on how to fill it in. I don't honestly, it's quite possible that the courts will accept a fill in the blank when it's using one of these Supreme Court forms, but that's not what the law says. The law says that it has to be 100% handwritten or 100% typed. So the recommendation is that if you do use these Supreme Court forms and they are and they're online, that you're going to want to fill in the blank. It's a fillable form. It's a fillable PDF. So you're going to want to fill in the blank online, and then you're going to print out a fully typed will, right? That's what you're going to do there. So be buyer beware if you decide to use something like that, that it needs to be either 100% in your own handwriting if you're using a template, or you're going to need to put it into 100% typed with witnesses. Okay. All right, those transfer on death documents that I keep talking about. So there are, remember what I said, that there's really three kind of major things that people think about for their property. They think about their house, their cars, and their bank accounts. Those are the three things that are really the things that impact probate the most for a lot of people. And so for houses and cars, the Texas State Legislature has done us a gift, and which has provided us with transfer on death documents. So houses and cars are probate assets. They will pass according to the will, typically. However, you can do these transfer on death documents, and that allows the property to pass immediately upon death without having to go through the probate process. So it's a bypass. For real property, this is known as a transfer on death deed, just like any other transfer of property when it comes to it requires a deed, a warranty deed, a quitclaim deed, a gift deed. It requires a deed. So you can do that with a transfer on death deed. And then what you will do is you will name your beneficiaries of the property, and then they will inherit the property effective immediately upon death. So that's the transfer on death deed. Then for your vehicles, and your vehicles also includes mobile homes and RVs. So places people live in, mobile homes and RVs also is a vehicle, and that's going to be a beneficiary designation of a motor vehicle. And so that is a form that you would complete and file with with DPS. And then when the person passes away, then they already have the new title. The death certificate is what puts it into effect for the vehicle. Good news is that you still own the property. You can do whatever you want. You can sell your house, you can sell your car, you can do whatever. It's still yours. If you sell it, then that transfer on death document is voided out. It no longer exists. It's not valid because you no longer own a property. But it can be done, right? So now some things to kind of be aware of is that a transfer on death document takes priority over a will, which means that once you file a transfer on death deed, doesn't matter what you have in your will, that property is going to pass according to that transfer on death deed. So, you write a transfer on death deed, giving the house to Bob, and then you write a will later on saying, I give this house to Susie. Bob gets the house, because you have a transfer on death deed to Bob. You write a will giving the house to Susie, and then you draw a transfer on death deed to Bob. Bob gets the house. Does not matter when that that transfer on death deed is executed. As long as it's executed and it's been filed in the county clerk where the property is located, it's a valid TOD, and it's going to pass according to that. It does not matter what the will says related to the exact same property. The only time the will come into effect is if for some reason the transfer on death deed is invalid. And so, and that's pretty rare. It's pretty rare for those documents to be invalid if they're drafted correctly. So, so just kind of be aware of that. There's a cost associated because it's a deed. You do have to file it. Same thing with the beneficiary designation. It's a title application. So you have to submit the title application to as well. So there's a cost associated with it. So just be aware of that. Not a big deal if that's what you want to do. It is also revocable. You can change your mind. So if you don't want to sell your house, but you decide you don't want that property to go to the individual that you name, you would file a revocation. And you would do, again, that has to be prepared and filed where that transfer on death deed was filed in order to revoke and then the property will pass according to the will. So for example, in my example, you did a transfer on death deed to Bob, you wrote a will giving the house to Susie, and then you did a revocation of the transfer on death deed. Transfer on death deed is no longer valid. Now the property is going to pass according to the will going to Susie. So, so just kind of be aware of that. Usually if people have questions about that and like what the effects are going to be, and you're kind of, trying to go back and forth on things, I do just generally recommend that you put those decision makings into a will, because a will can be, although you have witnesses and things like that, there's no expense associated with changing your mind, and it may be a little easier to update a will than it is to go through the process of updating transfer on death documents. But that depends on, again, your individual situation. Now, last thing to say about this, though, is that buyer beware, right? Or transferor beware, because it's not ideal in all situations. This is going to not go into the court process. And so because it's not going to go into the court process, there's no oversight. There's no ability for someone to be like, hey, let's make sure that what you want is actually going to happen. So really what we're talking about is the property is going to be going to one person. That's the ideal situation. One person's inheriting the property, and that's it. More than one person can inherit under one of these transfer on death documents, but the question becomes, is that what you want? And how did you want that to become into effect? So what are we trying to avoid with with estate planning documents? It's conflict. That's one of the things we're trying to avoid. And so if you have specific instructions that you want to put into your property, that's not going to, you can't enforce that in a transfer on death deed. That has to be enforceable in a court, in a probate court. So what are some of those examples? An example would be, okay, I know the kids are planning on selling the property. No one wants to live in it. That's not a big deal. But Susie, repaired my roof a few years ago, and I wouldn't, and I really think Susie should get the $10,000 back that she paid for my new roof. So I want Susie to get the first $10,000 of any proceeds, and then I want the proceeds to be split equally between Susie and Bob, right? And so those are instructions. So since those are instructions, those are better to go into a will, because again, verbal agreements are not enforceable. So if you want that to be guaranteed to happen, then you need to put that into a will, not into a transfer on death deed. If you trust your family and and that's going to do that, that's again, transfer beware. You are relying on people doing what they said they will do when you are no longer there to enforce it. And a court is not going to be able to come in and fix it if they end up not doing what they said they would do. Similarly, another example that's pretty common is that I want Susie to be able to live in the property for as long as she wants. Yes, she is. I want the property equally divided between Bob and Susie, but Susie has been staying with me, help me take care of me. Her kids are 12 and 14. I want them to be able to stay in this house, finish high school in this house if something happens to me while they're still living there. And that's what I want them to do. That is called a life estate. You would want to put those instructions into a will to make it enforceable, and then saying the property is split equally between the two of them. Now, multiple owners can still own it. That's not a big deal. That's right. That's possible. You can do that. You have co-owners on property, clearly. And if, so sometimes it's like, oh, the kids are going to sell it. And so this makes it so that they can do things pretty quickly and that kind of stuff, which is true. Other things to consider about, which is family dynamics that I am not going to be aware of. Again, we're trying to avoid conflict. Are they going to be able to agree? Are they going to be agree on a price? Do they know who's going to be in charge of making those decision makings on the uh on who's, are they going to make repairs before they sell the house, that type of thing. If you think that there's not going to be any problems with that, then you can do a transfer on death deed again. Otherwise, you're going to want to put that into a will, so that way the executor has the final say over how the property is sold and what needs to be done to the property before it gets sold. And so that's just kind of some examples. It's not everything. It's not exhaustive. I try to think of big things that a lot of people would think about. But those are kind of things on why you want to think about why a transfer on death deed versus the will in those kinds of scenarios. Okay. All right. Now, next up is trust. I'm not going to talk about trust very long. So trust is an arrangement where one person or an entity called a trustee holds legal title to property for another person called a beneficiary. Many different types of trusts that exist. There's living, revocable, irrevocable, special needs. It's like there's lots of different types of trusts that can exist. I always recommend that if you think you need a trust, you just discuss it with an attorney. It's honestly a pretty complicated topic to talk about really quickly, but I do want people to know that trusts do exist and they are part of estate planning for some people. For some people, a trust is what they need. I always say, what is your goal? What is the goal for your property at the end? A trust doesn't actually save money necessarily. For a trust that you have to prepare, right? Like, so you could just be shifting costs, right? Rather than paying for a probate attorney to handle the probate after a will, what you're having is paying an attorney to write the trust at the beginning. And so sometimes it's really what you're doing is just shifting the costs. But the reason why sometimes people think of trust is because of national conversation. So you may see a national financial expert who will say, estate planning is you need to do a trust. And I see a lot of TikToks that go out and say that. And so if you're watching TikToks where they're like, the first thing I would do is, destroy my will and create a trust and stuff like that. Please don't just do that. It's not always necessarily the case because one, I highly recommend that you don't write your own trust. Like so many problems can happen if you try to write your own trust. So don't do that. You need an attorney to help you do that. But in some states, trust is estate planning. That's what they do in that state because their probate process is very different. Estate planning and probate is a state law, is what happens in individual states. And we are in Texas, and what we are talking about is Texas law. The Texas probate process is actually not bad. Even though I just spent a few minutes talking about ways to avoid the probate process, it's really because why go through probate if you don't have to go through probate? But I also don't want you to be scared of the probate process if you need to go through it. A well-drafted, properly executed will results in one court visit, the time to admit the will into court, and the appointment of the executor. After that, it's a paperwork process. What happens is that the executor is going to do what they need to do. They're going to send letters to creditors. They're going to pay bills. They're going to write deeds. They're going to do all of this work that they need to do. And then the attorney is going to help file 2 more documents with the court. And then that's it. There's not going to court. It's just filing documents with the court. And then that's it. Yes, you have to hire an attorney, but that well-drafted will is going to help minimize the cost because the majority of the work is going to be able to be handled by the executor. And so that's a pretty simple process when you have a well-drafted, properly executed will. And so if that's the right way, the best way to affect what you want to have in your property, then that is what you should do. So don't be scared that just because there's a probate process that it's bad, because it's not necessarily going to be true. In some instances, it's what you need to do. It's the best way to accomplish what you want to accomplish in terms of expense and in terms of what you want to happen to your property. Now, that being said, you may need a trust. Trust usually comes into effect when we're planning for minors, adults living with disabilities, as I mentioned at the top of the presentation. High wealth individuals will do trust planning because they're of estate tax and making sure that property is passed the way it's supposed to be passed, according to that wealth management, wealth planning that they're trying to do. So there also is trusts that come into play when we're looking at getting access to long-term care health through Medicaid or through Medicaid. So there are trusts that are needed for different reasons. So that's the reason why I say you should talk to an attorney. What's the goal? What is it that you're thinking about that you want the goal to be for your property at the end of the day? And that may be a trust, but if the only goal is to avoid the probate process, that might not be a good use to have the expense of creating a trust. By the way, all that stuff I talked about what the executor would have to do, writing checks, doing, transferring property, doing the deeds and stuff like that, all of that will still have to be done, except that it's not going to be done under the trustee. So it's not even avoiding the work. The work is still being done. It's just depending on whether or not when it's being done, because it still potentially could still be done after the person passes away. So it's not really doing anything in the sense of like making the probate process easier because you're still going to have to do the same things. But again, it does depend on how the trust is written and that type of stuff. So just kind of keep that in mind. I'm not saying it's not an option, that it may not be what you need, but it may not be for the reasons that you hear it when you're seeing it on a national stage when they're talking about trust, because for many states, that trust is the way that they need to do it. Texas actually has a really, really good probate system in place if you need it. Okay. So now the bad news to have to share with everyone. Debt survives. Unfortunately, we do have to still pay our debts. The estate's responsible for it. It's not the heirs. The heirs are not responsible. There is sometimes some blurred lines about who's responsible for debt, particularly when it's community property and debt that the community may owe. But that's where I talk about, remember, key takeaway number one, everyone should go talk to an attorney, because you want to be able to think about what has to happen depending on, and the debt is one of the things that has to be discussed on what needs to happen to handle the debt. All real property is inherited subject to that debt. The debt doesn't go away just because the person has passed away. That's a misconception. Even the unsecured debt, the credit card debts and things like that, the debt still exists. The question is what happens to it? Like, does it get negotiated? Does it get discharged by the creditors, or do you have to pay the creditors? And so again, that's why you would want to speak to an attorney to figure out kind of what would be the expectations and recommendations after that. But I bring it up here because it's really important for you to be aware of the debt surviving when it comes to property as it relates to your house as well as your car, by the way. But most people, it's your house that is likely going to have that debt remaining, and that's going to be your mortgage and your reverse mortgage on your property, because this is a secured debt. What does that mean? That means that you owe money on a property that if you don't pay that debt, they're going to come and take it. They're going to foreclose your house, or they're going to repossess your car. So those inheritance are subject to that debt. So your beneficiaries for your house and your car, if there's debt on it, needs to be aware that they need to pay the debt, right? And so either you need to plan for that either you're going to have life insurance policy that's going to pay off that debt for them, or you're going to tell them, hey, by the way, there's still going to likely be a mortgage in the house when I pass, and you're going to have to somehow either sell the house or find financing to pay off that debt for yourself, and then you're going to pick up the payments after that, right? Like, so you're going to have to be aware of that. Now, some people will do that for me, or they'll tell the estate to pay off the mortgage. Some of it's like there isn't money in the estate to pay it, so this is the way that you need to be aware of it, or you're going to sell the house or etc., right? So there is a difference though between a mortgage and a reverse mortgage. For a mortgage, typically the finance institution will work with the executor for the probate to kind of get managed, right? Like, so you're going to notify of the passing, and then the executor is going to continue to make those mortgage payments, right? They're going to continue to pay the mortgage payments until they either sell the property or get, or the heir or the beneficiary is able to find new financing and things like that. As long as the debt's getting paid, right, the mortgage company will typically work with the estate in that timeline, right, and for it to happen. But with the reverse mortgage, it's very different. A reverse mortgage is due 6 months after the date of death is and that starts from the date of death. It's 6 months. I wish I can tell you that all reverse mortgage companies are really very understanding and will really work with timeline and things like that. They don't. Some of them are really pretty hardcore, and they will begin foreclosure processes on that 6-month timeline if there's no new financing and the debt hasn't been paid. And so if you have a reverse mortgage on the property, be sure that the heirs are aware of that there is a reverse mortgage. They're only going to have 6 months to be able to deal with it. Here's the issue though. Probates for most people, typical timeline is around 4 months when people start to probate. So they need to be aware that if there needs to be a probate process, that there's a reverse mortgage so they can begin that probate process really quickly to be able to do that. Solutions to that is, again, life insurance policies. If you know that the reverse mortgage and your life insurance will pay it off, make the person inheriting the property the beneficiary and get them the check so they can write the check to the mortgage company. You may want to consider doing transfer on death deed for that instead of going through the probate process. So that way they own the property immediately and then they are able to go seek out financing or be able to have the benefit of the full 6 months to try to repair it and then sell the property and get the full amount as opposed to trying to do it quickly in less than 2 months if they need to. So just kind of be aware of that. Those are things that you should probably talk to an attorney if you have a lot of questions around that. I can't cover all the specific scenarios and why you should do a certain thing or how you can plan around it, but just be aware your debt survives and that if you want that person to inherit the property, that part of the planning has to be how are we going to pay for that debt so that way the home is not foreclosed or the car is not repossessed. Okay. The last document when it comes to preparing for death is a disposition of remains. It's just a legal terminology to basically talk about who's going to be in charge of your funeral arrangements. So that names the agent who's going to be making those decisions. In that document itself, you can put instructions on prepaid arrangements, if any, or burial plots or burial or cremation instructions. It just helps create some clarity on who's going to be the one responsible for it. All right. I know we only have 30 minutes left and you're like, so much left to do. We will get through everything, I promise. So next up is that we're going to talk about planning for incapacity. So what is incapacity? Incapacity is when you're no longer able to make decisions for yourself. You are still with us, but we no longer have the cognitive. Something has happened to our minds in some way. Either we are living with dementia or we're unconscious, we're incapacitated physically, and we are no longer able to make decisions for ourselves. So that's what we are planning for when we're talking about planning for incapacity. This is a hypothetical. We're hoping it never happens, but we're preparing for it just in case. Sorry, hydrate. The first one to talk about is a supported decision-making agreement. This is not a document that everybody needs, but it's an important one if you do need it. So a supported decision-making agreement is one that's signed by an adult that requests a supporter to help with decision-making. This is not a power of attorney. The supporter does not make decisions on behalf of the adult. They're there to help support them, to help them make those decisions. And so, and that's really what it is. The supporter does owe a fiduciary duty, which means that by law that they have to do what's in the best interest of the adult, not in what they think is in the best interest. It's what is in the best interest of the adult and not what they would do, but what the adult wants to do for themselves. It's less restrictive than a guardianship, and it's usually used when someone has diminished or diminishing capacity. And so it's quite a useful tool for children as they age up into adulthood that are, depending on, their mental facilities, on whether or not they need supported decision making. But for those of us who are aging, it's helpful for those who are either in the early stages of dementia, they still have capacity, but they're starting to have those symptoms of dementia, but also just in general aging. Unfortunately, for some of us, as we age, we do just have a cognitive decline. It happens to some of us, not all of us, but for some of us, it does happen. And this helps kind of, there's a reason why when you think about those scams that they target elderly individuals for a reason is because of the inability to identify the scam when it's happening to them, right? And it's getting so good. Like, it's like how these scams work that sometimes they're just getting better and more realistic every time. And so sometimes even I have a hard time, I go through training and I look at it and sometimes I have a hard time identifying a scam, and I know it's a test. I know I'm trying to see where the scam is, and sometimes it's hard to find. But so what supported decision helps is that if a person comes into a bank wanting to transfer $5,000 out of country to somebody, the bank will have the supported decision-making document in place. They can call the supporter. Supporter can come and be like, hey, mom, dad, are you sure you really want to be sending $5,000 to this person that you've never met? Right? Like, and you can't stop them. It's not a power of attorney, but you can at least come in and be like, hey, please help me if I start making what seems to be odd decisions, and that type of thing. So that's where supported decision making is a useful document for some of us. Now, thinking about true incapacity, we are no longer able to make decisions for ourselves. What we are going to look at first is a statutory durable power of attorney. This is a document that names a person to make legal and financial decisions when we are unable to do so, typically when we're planning for incapacity. So, legal financial decisions, if there's a lawsuit pending, go make bank account payments, transfer property, like that type of stuff, right? That's what we're thinking about when we're talking about the statutory durable power of attorney. This one, though, does become, you have a choice in when to make it effective. You can make it effective immediately. What that means is that once you execute it, that the copy is given to your power of attorney, that they are able to go down to the bank and open a bank account in your name if if you've given them that power. And so that would be effective immediately. It also can be effective springing, and and the springing is that it's effective only when you're no longer able to make decisions for yourself. You have an incapacity, and an incapacity is determined by a doctor. A doctor does an examination and makes a determination that you are no longer able to make decisions. It isn't like some random person at a bank being like, nope, you have no incapacity. There has to be a doctor associated with making that decision. And so that would be the springing. There's no right or wrong here. Why would one choose one over the other? Convenience, really, it's really truly kind of convenience. The reason why someone may choose to make something effective immediately is a few things. To not have to wait for a doctor's appointment. Like you're just like, I want this person to be able to do what they need to do when they need to do it. And so I don't want to have to wait for a doctor to be able to make that decision. That's one. Another reason is that person is already helping. They're already a person who's doing things, already helping with financial and tasks and stuff like that. So you want them to have that ability to do it immediately. Or you're about to leave on a year-round cruise and travel around the world for a year, and you need somebody to be here locally to be able to take care of your house and pay your bills while you're gone. Then you would want that to be effective immediately, but you know that that's the person you still want to do it in the event of your incapacity later on. So there's a lot. So those are reasons, right? Those are reasons why you can make it effective immediately. It's a matter of convenience, but that's not right or wrong by any means. Plenty of people make it effective upon only incapacity after a doctor's examination, and there's nothing wrong with that. So you want, but you do want to have this in place. After that, we now start talking about medical power of attorney. So for a lot of these plannings for incapacity, we have two sides. We have planning for legal, financial matters, and then we have planning for medical decision making. And so you have two documents. You're going to have your statutory durable power of attorney, and then you're going to have your medical power of attorney. This names the person who's going to make medical decisions when you are unable to do so. This is only effective when you are incapacitated, because obviously, wherever you are, you're there to make your own medical decisions, right? Like it doesn't matter. You can be doing your 365-day trip around the world. You will still be able to make your own decisions as long as you have the capacity to do so. So it will always require a doctor's examination and a determination that there is incapacity for the medical power of attorney to go into effect. But again, that's just making it your so why are we going through this so quickly? Because the state has done a gift for us for this as well. The statutory durable power of attorney and the medical power of attorney, those are statutory forms. So the folks in Austin, remember Texas law, so the folks in Austin have already given us the form. They've already told us what the document should say for it to be effective. And so you're going to get copies of those templates of those documents afterwards with a link to the recording. And you're going to be able to see it. So it doesn't take a lot. You don't have to think about it. What you have to think about for your statutory durable power of attorney is what powers you want to give and why, in general. And then for the medical power of attorney, it's who's going to be your agent. So the key takeaway that we're going to bring up here has my fourth one. We've had four, right? First one, you got to do something after a person passes away. Go talk to an attorney. Everyone needs a will, regardless of their situation. Everyone gets a will. Be sure your heirs have access to the bank account. The fourth thing to be minimally protected for your estate planning, minimal, is everyone needs a statutory durable power of attorney and a medical power of attorney. If you take nothing else away, you're like, there's too much happening. I don't know what to do, Jesse. Tell me exactly what I need to do. Your four things that you're going to need to do. You're going to write a will, preferably self-proving, but if not, witnesses, if not witnesses, handwritten. You're going to go to your bank and you're going to either make it add an owner, or you're going to make it a payable on death account. Number 2. Number 3, you're going to sign and execute a statutory durable power of attorney. Number 4, you're going to sign and execute a medical power of attorney. Those are the 4 things you must do to have the minimum protection for estate planning. And what I would feel comfortable with, if you're saying I can't do all of it, this is what that would be the minimum. It's not everything you should do, but or can do, but that's the minimum you should do and should have as part of your estate planning preparation. Now, I did talk about notarizing and things like that. The will, just to let you know, and I'll remind everyone again at the end that NRCDC does have an ability to help people notarize wills if you are preparing your own wills, and it is also something that we may be able to do at these resource fairs in the future as well. So there are opportunities. Not every notary will notarize a will. I forgot to mention that when we were talking about the will, but just kind of be aware of that. All right. So now let's talk about the rest of the stuff that you should have if you can get the capacity to be able to do it, to be fully prepared. Designation of a guardian in the event of later incapacity. So the medical power of attorney and the statutory durable power of attorney just requires only a doctor to make an examination to put them into effect. Sometimes when there's a permanent incapacity, which is that there's not an expectation for a person to regain the ability to make their own decisions. So with the power of attorneys, it's temporary, possibly, right? You're having surgery, so you're not able to make decisions because you have surgery. Doctor's gonna be like, they're unconscious. They cannot make a decision. We need the medical power of attorney to make a decision about medical care, right? But when you wake up, you're going to have all of your cognitive functions back. You're going to be able to make your decisions for your ongoing care at that point in time. When we're talking about a guardianship being put into effect, we're assuming there's not going to be a regaining of capacity. There is the dementia is there. The person is permanently unconscious in a coma. So, right, like that's what we're going to be talking about when it comes to establishing a guardianship. And now we have to go through the court process of naming that person. And this document is going to basically say who's going to be that guardian or who you want to be that guardian. And it's going to be just like the power of attorneys, where there's one for your medical care, and then there's one for your legal and financial care. You have one for your persons. That's the person that's going to make decisions on where you live, what kind of medical care you're going to get. And then there's a guardianship for your estate, who's going to handle your property, your finances, and your legal affairs. So that's who you're going to be naming. Excuse me, I'm sorry, I'm getting over a cold. My medicine's wearing off. So this is one of the things that's also really important about this document that can be just as important to a lot of people, is that you can disqualify a person from serving as a guardian. So the court still has to approve the person. They still have to qualify, but they're going to take this document into account. They're going to be like, okay, well, the first person they want is Bob. All right, fantastic. Bob sounds great. We'll take a look at Bob, but now we find out that Bob can't serve for whatever reason. He himself is incapacitated, no longer lives in the country, declines to do it, right? Like there's reasons why Bob may not be able to do it. Then we go look at the alternate, for alternate Susie, and for some reason Susie is not able to serve. Now the court has to go look to see who else can serve in that role, right? They're going to go look for next of kin. And so they're going to like, all right, well, the next of kin is going to be, Barbara. And, you're like, but I don't like Barbara. I haven't talked to Barbara in 30 years. We hate each other. Just because we're related by blood doesn't mean we're family, right? Like, so your document can say, not Barbara. Barbara's bad. I don't want her to ever serve. And the court's going to say, okay, this person has said Barbara can never serve as the guardian, so Barbara is not going to serve as the guardian. Now we're going to go find the next person that can potentially serve after that. And no offense to anybody named Barbara out there. I'm just literally just pulling a name out of my head. So, I have a very good friend who's a Barbara. So don't come at me being like, what's wrong with Barbara's? But that is just as important for some people, and be aware that you can do that. And so that if you want to make sure that someone never serves in that role, the court will take that 100% into account and not name that person. The execution requirements for a declaration of a guardianship of a guardian in later incapacity, by the way, is the same as a will because of that court process, right? Just kind of just putting that together, like the rules around witnesses and notaries and the self-proving affidavit for a will applies to the declaration of a guardian, in the event of later incapacity, because it is going to a court, and the court is looking at everything to make a decision on what to do. HIPAA release. So HIPAA gets a lot of news coverage and sometimes a lot of misinformation around HIPAA. So what is HIPAA? HIPAA is the Health Insurance Portability and Accountability Act. What it does is that it protects medical information. It's actually electronic medical information, but for the most part, what we're talking about is medical information and it cannot be shared by people governed by HIPAA without the express permission of the person whose medical information it belongs to, right? So a HIPAA release gives that express permission for those covered individuals to share that information with the people named in that document. So just to make it clear, hospitals, doctors, those are all people who are covered by HIPAA. By the way, so are lawyers. Lawyers are covered by HIPAA. So who's not covered by HIPAA? You tell your neighbor about your high blood pressure. Neighbor can most definitely share that with anybody, right? Like they're not covered by HIPAA. So it's certain individuals who are covered by this. But you're going to want to include a HIPAA release as part of your estate planning packages, because you want your medical power of attorney as well as your guardian in the event of a later incapacity to be able to get access to medical information from all of your doctors. And this is considered a general release. It applies to everybody as opposed to an individual release that you may sign with your individual doctor. So that's why it's included as part of the estate planning package. So that way you have that broad protection that you need to be able to make this happen. Next up is the Advanced Directive to Physicians. This is a heavy document for some people, and I don't want to make light of it, but just be aware it's commonly known as a living will, and it is end of life decision making, and it applies in two situations. The first one is a terminal condition. A terminal condition has been defined as a person is expected to pass within 6 months from that condition, even with life-sustaining treatments. An example of this would be stage 4 pancreatic cancer. Typically, the life expectancy at that stage is usually less than 6 months or just soon over that. So that would be an example of a diagnosis, right? Now, I'm not a doctor. I'm not here to say that that's always that, right? I'm just saying that that would be an example that someone will have. And then there is an irreversible condition. An irreversible condition in and of itself is not terminal. A person can live in that state of that condition. But it can become terminal if there is not an intervention for life-sustaining treatment. An example of that would be a person in a coma. A person can live in a coma for years. We know that. But in order to survive, the person needs nutrition. So you would need to have artificial nutrition as part of that life-sustaining treatment in that intervention. So those are the two situations. You could have different choices for each one. You don't have to have the same. So the options are, you can stop treatment, keep me comfortable, but let me pass peacefully. The other option is to use all life-sustaining treatments. Within that, if the choice is to use all life-sustaining treatments, you can also add additional instructions into that, which can be that I want all life-sustaining treatments to be utilized, but I never want to be put on a respirator. Like you can, and in the event that I would be put onto a respirator, I would like to be able to make me comfortable, let me pass peacefully. So those are also those types of instructions that you can have. So you can put conditions and expectations within those decisions. There is a possibility, the templates don't include this, but you could have the decision to be made by the medical power of attorney after conferring with a physician. And it's not common because usually a lot of people, when they complete these documents, know what they want. They have a decision they want to make. But if you do decide you want your MPOA to make that decision on your behalf, be sure you have conversations with them about what you would want, explain situations, explain the decision making, so that way they are not caught off guard and they are able to make what is a very heavy decision, fully empowered, fully aware. And if it is something that applies to you and your family, you may want to seek out spiritual guidance and counseling, and to have those conversations, to give forgiveness if needed, and those types of things, and to make it as easy as possible for a person who probably loves you very much to make a very difficult decision. Just be aware this does not replace a hospice plan. As always, as long as you have the ability to make your own decisions will cover. So when a person enters hospice, the hospice plan will govern over the advanced planning, the advanced directive. The last document that you can prepare for mental incapacity is a declaration for mental health treatment. This is a document that not everybody needs, but it's a really important one for those who do need it. It's also known as a psychiatric advance directive. It is for individuals who are at risk or have a history of psychiatric hospitalizations. Examples would be schizophrenia, would be a person who may want to consider having one of these documents in place. It helps them make decisions in advance on psychoactive medication, convulsive therapy, and emergency mental health treatment in the event that they are hospitalized. Really, really important document. If you know anybody for this document may apply, super helpful. Not everybody knows that they exist. It's been a lot of outreach to let people know it does exist, but it really, really vital for those individuals. Unlike the other estate planning documents, this one does expire. It expires every 3 years and it has to be re-executed every 3 years. So if a person has already executed one and they may have had it done more than 3 years ago, they need to do a new one for it to be valid. A hospital psychiatric hospitalizations does require a court order, and so it is helpful to have the documents with treating physicians as well as family members, so that way if the hospitalization is ordered, they can provide a copy of the document to the hospital. Okay. All right, that's all of the estate planning documents, believe it or not. In 10 minutes, we're going to cover the rest of the things. So very briefly, I'm going to talk about long-term care planning. Long-term care planning is basically you're thinking about how to access that care. Planning for Medicaid is really what we're talking about. And then protecting assets from creditors, including the Medicaid Estate Recovery Program. There's not, again, this is in itself a pretty big topic, and so we can't cover everything on what you need to do, but you do need to be thinking about it. So what we're talking about when we call long-term care is that fortunately, as a society, we are living longer, but that also means that some of us are going to end up needing nursing home care. We're going to need to have some kind of living facility. That has nothing to do with our mental capacity. It may or may not. It could be physical. We need physical assistance. And so we're going to go into care. And that is what we're looking at. And so Medicare covers a certain portion of that. But for once Medicare benefits run out, then you need to become eligible for Medicaid and to cover that. And that will require moving property into ownership in such a way to become eligible for Medicaid. And also the state does have a right to reclaim some of the costs that they put into the care. And that is the Medicaid Estate Recovery Program. And so some of the planning that we're going into is to try to protect the property from that. There's ways to do it. Don't be worried. There are ways to do it. There's ways to do it with real property through an enhanced life estate, commonly known as a Lady Bird deed. You can also protect the property through a transfer on death deed. To become eligible for Medicaid, you do have to think about the income coming into the household, in which case you would want to take a look at a qualified income trust, normally known as a Miller Trust, in order to allow for income to come into the home and qualify for Medicaid. All of this should be discussed with an attorney. There can be a lot of unintended consequences when it comes to try to planning for long-term care. So if you believe that this is something that is in your future and you want to be thinking about it, you're going to want to speak with an attorney to take a look at your property, your assets, to see if any of that will impact eligibility, and if so, what kind of planning needs to go ahead and be put into place to allow for that to happen. So what's next? You're going to want to create a list of accounts, your bank accounts, life insurance policies, retirement accounts, all that stuff. All that stuff I talked about an hour and a half ago. You're going to want to make a list of your accounts and phone numbers and things like that, so that way your executor knows where it is. You're going to want to be sure that your executor can access your digital accounts. Who can get into your phone, your computer, and because they're going to need to manage your digital assets as well. Personal property includes digital assets, your digital pictures and that kind of stuff. So you're going to want to be sure that they know how to be able to get access to that. Be really careful about passwords. You do need to change your passwords all the time and all that kind of stuff. Like, don't write it down and make it easily findable. But there are solutions around that, and there's a lot of practical solutions to be able to do that. Where to keep your documents. Keep them in a safe place. Is it your safety deposit box? Maybe, maybe not. Things to think about when it comes to your safety deposit box. In order to open that box, the person has to have a key and be on the account. Both. It cannot be one or the other. And if they don't have either, then it does require a court order to open up a safety deposit box. And only the person who's named as the executor on that document can walk out of that bank with the will. So just kind of be aware of that. So I don't usually recommend a safety deposit box for many people. I usually recommend that you keep it where you keep your safe documents. Where do you keep your social security card, your birth certificates, your passports? Most of the time, that's just not laying about somewhere, So, but put it there. That's typically where I keep it. Someplace safe, secure, not easily discoverable by bad actors who may wander into your home for some weird reason. And let your executor know where it is. If it's under a lock and key in some way, let the executor know the combination to your safe, or give them a copy of the key, or let them know where they can find the key. The county clerk, I already mentioned this a little bit when we were talking about the will. The will can be filed with the county clerk, not required, but it is a way for safekeeping if you wish to do so. It is not public record. Just because you file it with the county clerk, it stays it is private. No one can look and find your will while you are still with us and before probate is filed. Be sure you discuss all of this with your family members and your representatives so they know where everything is and what your decisions are and what you would like to do. All right. One more slide of those key takeaways. Remember, everyone's got to do something after a person. Someone's got to do something after a person passed away. That thing is to talk to an attorney. Everyone needs a will. I don't care what your situation. I don't care what the thing is before. Get a will. Be sure there's access to the bank account, either through a payable on death account or some type of joint ownership. Either has a joint owner or a joint tenancy with a right of survivorship. Everyone needs a statutory durable power of attorney and a medical power of attorney, and those are the things you need to do to be minimally protected. Everything else is a wonderful thing to have. You should get them if you can, but they're not absolutely required. Help is available. This is overwhelming. Lots of stuff that I just mentioned, right? And you're like, oh, I don't know if I can do that on my own, Jesse. That was an awful lot of stuff. There was too much to think about. Remember, you're going to get a copy of this recording. You can come back and you can rewatch it. You can go to the spots that you feel like you need to have more things to be able to talk about. So don't freak out. But there is help available. We do have our partners as part of AMOS, in addition to Lone Star Legal Aid. That's me. This is my contact information. That's how you can apply to my organization. But we also have in our partnership Houston Volunteer Lawyers and the Earl Carl Institute. They also help with estate planning. And so you can apply for services with them. There is also a general way you can apply with the City of Houston, and they can direct you to the appropriate partners. Houston Lawyer Referral Service, that is a service of the Houston Bar Association. These are private attorneys. You do pay them to help you draft your will, so just be aware of that. But they do can provide you the names with attorneys that can help you do that if you don't qualify for services. That's a way you can find an attorney. Do not ask me how much attorneys cost. It depends on their experience, the complexities of your estate planning. I just don't know. I don't know how much lawyers cost when they do this type of work. And then the last one is that if you decide you want to try to do these on your own, and in addition to rewatching these videos, you can go to Texas Law Help. This is a self-help website. It's an excellent website maintained by our partner at Texas Legal Services Center. And not in addition to estate planning, there's a lot of self-help information around family, consumer, all sorts of civil legal needs. So it's an excellent website that I can recommend for you to go take a look at. Reminder again of all the other programming that's coming up next week on Thursday to talk about the probate side of things, the other side of the coin of what I talked about today. Conversation and Coffee at A-Leaf on the 22nd. That's where you can come and apply for services or ask us questions. Again, if you are planning to come in because you want to ask us a specific individual question, or you want us to be able to help you draft your documents for free, if you're an eligible client, we do recommend that you apply before you arrive through those links that I gave you on phone numbers. And then in 1 month from today, on November 7th, I will be doing a presentation on how to go into the weeds, how to write your own estate planning using those Texas Supreme Court approved forms, as well as a transfer on death deed. And I always like to end with a little funny. This is a heavy topic. I know it's hard to talk about death and incapacity for 2 hours, but it's really important, and I do appreciate your attention. But I do try to end on a slight happy, a silly note. And this is Mrs. Head is at the attorney's office, and she wants to leave all of her estate to her sister, but she's not. But if she's not living, then she wants it in trust for her eggs. So be like Mrs. Head and be prepared. I know we're right at the top of the hour and the session is supposed to end. I could stay on for a few minutes if anyone does have any questions. Ms. Dia is going to ask the questions that were already submitted to her. If you want to type it into the chat, for those of you who are on Zoom, please do that. Those of you who are watching online, you can comment, but just be aware we are on a public space. Please do not put any individual private information that can come into that can be taken against you. So with that, I hand it back to Ms. Dia to moderate Q&A.
All right. Again, that was a lot of information. We know that you guys will have questions or something that's going to come up later. Again, you can feel free to come back and attend these sessions as often as you like because they are free. We do these on a monthly basis because one, new questions arise from different people that sometimes we do or do not address from a previous workshop that we just didn't think about, or processes change, laws change, and things like that. So we want to make sure that you have the most current information that you can possibly get. So you already answered the question about what exactly is a transfer on death deed, but can you go to the next slide about the other upcoming? I did want to add, yesterday, what's today? Thursday, Tuesday, we had a summation of probate matters with Judge Medina from the probate court number 2, who was actually on and did a presentation about basically from the judge's perspective. What do they see? What happens? What's the process for people going through probate and how they show up for court and things like that? It was a very good conversation. So when I send out the link of the presentation for this, I will also include the presentation that she presented as well. And it was a little bit more detail about probate matters, because what we're going to be going over next week, she's going to go over other probate concerns that people might have. But it's going to be more focused also on inherited property. What do you have? What happens when you have multiple heirs? You need to clear title and heirship affidavits and things of that nature that need to be done when you've got that property that's handed over to you. But I definitely will include the link for that presentation to be there as well. In addition to that, the resources that are on the other page that she had that had all of the legal service organizations, the Legal Lines and Houston Law Referral Service, all of those resources will be included in the email that I send out to you all as well. So don't worry about that you didn't write it down or anything like that. So you will get the links and also the links for the organization so that you can go and apply in advance for their services. But question that I had here, do you still need a will even if you have a few life insurance policies?
You still need a will if you have life insurance policies, yes, because everyone needs a will no matter what. Things happen with life insurance policies. One, beneficiaries can pass away, and if there's not an alternate, then it's going to go to the estate and it's going to pass according to the will. But things do happen, right? And another kind of example of how you might want the beneficiary to be the estate to help pay that mortgage, potentially, right? So yes, no matter what, you still need a will, even if you have other things in place. Even if you have all the other stuff, by the way, you have a transfer on death deed, you have beneficiary designation, payable on death accounts for everything that you own and your bank accounts, you're still going to want a will, because people do come to me thinking that they were fully covered, and then the heirs discover some property for which a will is needed.
Okay. If someone, I'm going to summarize this one because this was a real specific question. If someone were to receive like some kind of a settlement where they are to receive like yearly payments after someone passes away, how do you secure that, or what happens when you've got payments that are coming in after the person has passed?
I don't know if I can actually answer the question because I think it depends on I'm guessing they're
What
talking.
exactly it is?
I think they're talking about an annuity, right? But I think it just kind of depends on what's going on. I think it's just like most things that we have to kind of see the person who's receiving the funds. Do we have to worry about it? Like protecting other benefits? Does it need to go into some type of a trust? Does it need to, um, so in order to be able to protect it? So I think I think that's one of those situations where we kind of need to know more about what it is that they're receiving and why and how, right? And who's receiving it and why and how, and in order to be able to truly be able to do that. But as with most assets, a lot of that would be protected and planned for in a will, or in this case, it sounds like something that would be worked out with the financial institution. It's likely a non-probate asset for which the financial institution will have documents that need to be completed to determine what happens after that.
Okay. In a situation where a father or dad passed years ago, the mother be named the executive, but leaving everything to the children. Oh, you cannot do a transfer. Basically, they want to know, can you do a transfer on death deed after someone passes away?
No, no. Once a person passes away, then it has to go through whatever the probate or probate alternative options that are available. Transfer on death deed has to be completed by the current homeowner while they are alive, and to do that. So transfer on death deed is a planning document. It is not an after document. So the options that are available are going to depend on situation. So I highly recommend that individual attend a session next week on clearing title.
Okay. Mother recently passed away. Her husband trying to sell her house. And she bought the house. Okay, that one's really specific about a house fire and husband, new husband. We're not gonna get into that one. Good news to you, we will. If you are if you have property here in Texas, but you live out of state, what's the best way to go about making sure that property here, the mother's property is here? I'm sorry, take that back. Single mother of two siblings and without family in the state or in the country. How do I need to protect those assets?
Um, Not sure exactly what the question is, but I'll try to. I'm going to answer broadly, like in general, like what happens when the person's here and there's no one here. Maybe that will get the answer that
Yeah,
they're.
that's
Let me know if
basically
it's
it.
not
That's
what
what
it
it's
is.
getting down to it. Yeah, that's
Okay.
what it's basically getting to.
So we are Texas law applies. So in order for property that's located in the state of Texas to pass in Texas, it needs to kind of follow the laws there, right? And that's ways you can do that. Transfer on death deed is a way to do it. Again, assuming that it works and it applies to be able for property to get passed. You don't have to live in the state of Texas to own property in the state of Texas, right? So anybody can inherit it wherever they live. Right. So that is basically it. So if the question is trying to get to how can a person who has property pass property on to somebody who doesn't live in the state, that's basically kind of how you can do it with transfer on death deed, assuming that the transfer on death deed really is the best approach. But otherwise, it will go through a will, and a will would be able to do that. An executor also does not have to live in the state of Texas in order to be able to serve as an executor. It does create some complications. You have to appoint somebody locally to serve as the local person, but that's typically going to be the attorney you hire anyways, to be able to do that. So it is generally probably preferable to have somebody who's located here to be able to make those decisions and things like that, but not impossible, not required. So you can have a person who doesn't live in Texas serve as the executor, if that's kind of the crux of the question that's being asked there.
Yeah, the mother passed without family here in Texas or in the country actually, and she needs to know how to get the will executed. when
Okay,
they are
well
out of
now we're
state.
talking about the after part, right? So for those people who are currently with us and are thinking, I live in Texas, but everyone else I know does not live in Texas, or when I'm related to, that's the answer I gave. So now we're talking about a person who is passed and there's no one in the state. The probate still has to happen in the state of Texas. The property is located here. This is where the person passed away. So again, I probably would recommend that individual go to the session next week to hear about what the options are when it comes to the probate side of things.
Okay. Blah, 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 blah. I kind of want to touch back on transfer on death deeds as well, that a transfer on death deed is not available per se in all states, or it's not recognized in all states. So when we're telling people about doing a transfer on death deed, they automatically assume that they can do it in the state where they are as well. So that they need to make sure that that state, wherever that property is.
Right. Wonderful reminder for everybody. Everything I
Yeah.
talked about today only applies in the state of Texas, that I can speak on. It may apply in another state, but I don't know. Don't trust me to tell you what happens in Missouri. I don't know what happens in Missouri. So, so everything I talked about today is Texas, property located in Texas, person living and residing, resident of Texas. That is what I'm talking about. If you have property in another state, even if you reside here in Texas, you're going to need to look to see what the laws are in that state to be able to effectively pass title to property in that state. If it's a will or a trust or transfer on death deed or things along that lines, right? And so just be aware that things, kind of going back to what I talked about the trust, the reason why trust is talked about a lot is because in some states that is the planning. You don't write a will, you write a trust. In here in Texas, you would write a will, not a trust. So just kind of you have to look at the individual state where that property is located.
So when it kind of to dig a little deeper into this. So if someone has a property in another state, but they're creating a will, they live here, they have property here, they're creating a will, do they include that other property that's in another state in their existing will, or would they have to create a separate will? Or that's
I don't
still,
know.
you have to dig into it a little deeper in another state?
Yeah, I don't know. You would have to look in the other state on whether or not they will
Yeah.
accept an out-of-state will to pass the property in that state, or if they would want something else. Maybe that state has its own transfer on death document that's available to them. This is not unique in Texas. There are states that have these documents in other states. So you would have to kind of look in that other state to see what would be kind of needed in that state to transfer a property. There are things that can be done. We're about to start going outside the scope of this presentation when a person passes away and they have property in other states and their wills are in some states or whatever, right? There are things that can be done. But when you're talking about the planning side of it, the best thing to do is to go to that state, find an attorney there or find a similar type of presentation there and take a look at what the laws are there that would require what would happen to property and after death there.
Okay. Do your research.
Do your
Do
research,
your
everybody.
research. Do your research. This was creating a trust. You already covered creating a will. I think I got through everybody else's questions without digging too deep and trying to paraphrase. If I did not paraphrase your questions adequately, then please make sure that you reach out to us and let me know, because again, I didn't want to get too specific with asking the questions that they actually asked in the emails. So with that being said, heavy topic, yes. Thanks for the stories of Bob, Susie, and Barbara. It helped me to understand a lot of things that can break it down into real life. So thank you very much. Yes, indeed, that does help quite a bit when you've got those little scenarios that come up. Oh, I forgot this thing is that motion sensitive when I had my hands up that it thinks I'm asking a question. But yes, it does help with those kind of things that having those little scenarios does help. So everyone's talking and lower the hands. Okay. Um, yeah, it helps to kind of put those things into perspective. So, I think that's about it. If there are no other questions, I don't see any in the chat and I don't see any on social media either. So, with that being it, if you guys don't have anything else to add, hopefully you guys can tune in next week for I guess this month it will be kind of be part 3 of of advanced planning and wills and probates and things of that nature next Thursday for the inherited property presentation. That's done by Miss Lisa Nelson with the Texas Legal Services Center, as well as the county appraisal district and the tax assessor collector's office, because they go into talking about when someone passes away and they have had deferred property taxes, or they've got multiple heirs and the heirship exemptions and things like that are available. So that kind of go hand in hand. We kind of started adding things over the years. This program has evolved tremendously to where we're up to 12 to 15 different workshops on a monthly basis, when we were only doing one before. But then there were so many questions that kind of came afterwards, which is why we ended up splitting and then doing probate stuff and then doing clear and title stuff and adding this and adding that. But it's because of the questions that we receive from all of you guys, and the input that we get from you and what exactly is it you need. So if there are workshops that we don't currently offer that you all are interested in the next couple of months, we will be going into our planning session for 2025, and ask that you reach out to us and let us know and say, hey, this is a big topic of something that's going on in my community, or this is an issue that I've come across quite a bit, and could you guys elaborate a little bit more on, or something to that effect. Reach out to us and let us know. In addition to that, we'd also love to hear from you. If you all have found these presentations to be beneficial, please let us know, because otherwise, we're just giving them and then you guys are like, why are they still doing these? Or I don't like these anymore, or whatever it is. Please just let us know, and hopefully that the information that you or your loved ones have heard has been beneficial in some capacity, one way or another. But there's a survey link that pops up at the end of this. If you could just take a couple of minutes and complete the survey, and again, let us know how we're doing. What do you think about the programs, and if there's again something that we're missing. So we appreciate you all for joining. We appreciate you all for sticking around for a little bit longer to complete all the questions and to get all the information. We are here with Ms. Jessie the the first Thursday of each month. So feel free to come back and hear the information again. We ask that you pay it forward, share it, have the conversations with your neighbors, with your relatives, especially those older relatives that do not like having conversations about wills and estate plans and what needs to happen. And I always try to reiterate that if nothing else, if you got nothing else from COVID, that know that anything can happen at any time, and that it does not matter your age, it does not matter where you live, it does not matter your financial status or what have you. People were going into the hospital without having plans in place, that nobody was able to make medical decisions for them. There were people that were, financially, you know, what's the word, debilitated, or had no ability to get to their finances because someone was in the hospital or had passed, because nothing was actually put in place. Make sure that you do what you need to do to protect your family, protect your assets, and put a plan in place. You always say, Jesse, it's better to have it in place and not need it than to need it and then not have it. So there you go. That's your other takeaway. Make sure that you get it done. Thank you all for joining us. Continue to support a month of service. You all have a wonderful remainder of your day. Take care of yourselves and stay safe. And we will see you all next time. Thank you so much, Jesse.